Honorable Supreme Court of India. Let us observe 2 minutes silence. Jai Jagan. Respected Honorable Justice Ms. Savitri Ratha, the judge of this Honorable Court. Respected Honorable Judges present in the virtual mode, the Lord and senior members and the members of our High Court Bar Association, respected family members of late Barrister Ranjit Mahanty, and my dear friends, I welcome 33rd commemorative function of late Barrister Ranjit Mahanty, which is being held in hybrid mode. In this auspicious occasion, my Lord Honorable Dr. Justice S. Muralidhar, the head of this institution and the head of the legal fraternity of Odisha, has given his kind consent in spite of his busy schedule as the chief guest of this function. May I now request Honorable Dr. Justice S. Muralidhar, the Honorable Chief Justice of Odisha High Court, may kindly join us to the virtual platform. May I now request the eminent jurist, constitutionalist, honorable member of Rajya Sabha, Sri Moez Jethamalini, senior advocate, Supreme Court of India, who has given his kind consent as the chief speaker of this evening, may kindly join with us to the virtual platform. Thank you, sir. May I now request our guide, the convener of the Barrister Ranjit Mahanty Memorial Committee, Senior Advocate Sri Ranjit Kumar Mahanty, kindly come to the dais. Thank you, sir. May I now request Sri Kirut Kumar Rao, the Vice President of High Court Bar Association, may kindly come to the dais. I request Sri Rosmi Ranjan Mishra, Assistant Secretary, High Court Bar Association, kindly come to the dais. Now I request the honorable dignitaries kindly lighting the lamp and give floral tribute to the photograph of late Barrister Ranjit Mahanty and inaugurate the function. May I now request Mr. Kiran Kumar Rao, the Vice President of High Court Bar Association, kindly preside over the meeting.
Good evening. On behalf of High Court Bar Association and Barrister Ranjit Mahanty Memorial Committee, I extend a hearty and warm welcome to you all. Today we are here to observe the 33rd Commemorative Day and the law lecture at this hall. And first, I request Mr. Ranjit Mahanty, a senior member of our bar and also a lovable personality, to give the welcome address. Mr. Mahanty.
Good evening, Namaskar. I, as the convener of Ranjit Mahanty Memorial Committee, welcome all my guests who are present here physically as well as in virtual mode. At the outset, I cordially welcome our distinguished guest, Honorable Dr. Justice Muralidhar, the Chief Justice of Orissa High Court, and Sri Mahesh Chatmalani, eminent jurist and Honorable Member of Parliament, who are in virtual mode. I also welcome Sri Mr. Justice Sangam Kumar Sahu, the Judge of Orissa High Court, who is physically present here and has come to inspire us. On all occasions, he requests our invitation and he inspires us. I am really grateful to him. I welcome the Honorable Judges of Orissa High Court and esteemed members of the bar and the others who have joined us for this commemorative day. I welcome Honorable Justice Ranjit Mahanty, the Chief Justice of Tripura High Court, who is also participating in the program in virtual mode. Ladies and gentlemen, I welcome the guests who have joined us today for this commemorative day, and this is an auspicious day. We are observing this 33rd commemorative day of the Barrister Ranjit Mahanty. This is the day on which the doyen of the bar, my reverend senior, eminent jurist, Barrister Ranjit Mahanty had left us for his heavenly abode, but leaving behind his illustrious saga of professional excellence, philanthropy, charity, vision, and social service. It is my honor to say that apart from being a doyen of the legal profession, Barrister Mahanty was also a social activist, humanist, a leader of the bar, and also the masses. Barrister Mahanty, the third generation lawyer, was called to the bar from the Lincoln's Inn and was also first Asian to top the bar examination held in 1954. Started his legal practice in 1956, and he held the post of Vice Chairman at the Bar Council of India as well as the Chairman of Bar Council of India for 2 terms. He was also President of the Orissa High Court Bar Association for 2 terms. He was also President of All Orissa Lawyers Association and led many trade union activities. Barrister Ranjit Mahanty was a thinker, visionary, and astute organizer, and was instrumental in founding the National Law Institute at Bangalore. Though he has passed away at an early age, his vision for legal education, more particularly the 5-year law course, has become a great success, with the NLUs being established in almost all states. NLU were established to provide the best legal education, which in turn serve the country in legal field and in judicial. He had the unique ability and leadership to unite the masses with the bar. He was revered all through the state, not only as a lawyer, but also as a gentleman, and he has a great mass appeal. I pay my homage to be the great soul of a human being. Today we take the inspiration from his works and life to strive towards the mission for the healthy contribution to the society and judiciary. With this, I take the leave and I request the President to go further so that our two eminent, the jurist Honorable Chief Justice as well as Mahesh Jethmalani, he would be introduced by our young friend.
Thank you, Sandeep bhai. Now may I request Mr. Subha Vikas Panda to introduce the guest.
Chief guest, Honorable Dr. Justice S. Muralidhar. Dr. Justice S. Muralidhar was appointed as a judge of High Court of Delhi on 29th May 2006. During his almost 14-year stint as a judge of the High Court of Delhi, he pronounced various landmark judgments dealing with a variety of issues. He later assumed office as a judge of the High Court of Punjab and Haryana on 6th of March 2020. On 4th of January 2021, Dr. Justice Muralidhar assumed the august office of the Chief Justice of Odisha High Court and is continuing as such till date. Justice Muralidhar completed his Bachelor of Science Chemistry from the Vivekananda College, Chennai, securing first class from the Madras University in 1981. He secured first rank in the Bachelor of Law course from the University of Madras and was awarded with many prizes and medals. As a law student, he was a part of a two-member team of Madras Law College that won the All India Moot Court competition and consequently represented India at the 25th Philip C. Jessup International Law Moot Court competition held at Washington, D.C. in April 1984. He completed his LLM specializing in constitutional and administrative law from Nagpur University in 1990, securing first rank. He was awarded PhD by the University of Delhi in February 2003 for a doctoral program entitled Legal Aid and the Criminal Justice System in India. He is also a fellow of the Institute of Company Secretary of India. As a distinguished judge of higher judiciary, Justice Muralidhar had so far authored many landmark judgments. He is the author of the judgment of Rajendra Gobir versus Air India Limited 2007, which dealt with gender discrimination in service conditions of cabin crew. He also dealt with issue of reproductive health in Lakshmi Mandal versus Deendayal Harinagar Hospital in 2010, which highlighted the deficiencies in the implementation of a cluster of schemes funded by the Government of India, which were meant to reduce infant and maternal mortality and the resultant systemic failure that led to the denial of benefits of two mothers below the poverty line during their pregnancy and immediately thereafter. He laid down that when it comes to the question of public health, no woman, more so a pregnant woman, should be denied the facility of treatment at any stage of irrespective of her social and economic background. He laid down that right to health is inherent to right to life. In Sudama Singh versus Government of Delhi, while dealing with the resettlement of Jhuggi Hotmets inhabitants, he was a part of the division bench which held that the decision of the government that Jhuggi inhabitants are on the right of way and are therefore not entitled to reallocation as illegal and unconstitutional. The court further directed that the state agencies will ensure that basic civic amenities consistent with the rights of to life and dignity of each of the citizens in the Jhuggis are available at the site of relocation. Similarly, in Ajay McCain and others versus Union of India 2019, a PIL which dealt with the forced eviction of 5,000 Jhuggi Hutments dwellers in 2015, Dr. Justice Muralidhar authored the judgment on behalf of the division bench, which held that a court approached by persons complaining against forced eviction should not view them as encroachers and illegal occupants of land, but rather to require the agencies to first determine if the dwellers are eligible for rehabilitation in the terms of extant law and policy. It was held that the right to housing includes the right to livelihood, right to health, right to education, and right to food, including right to clean drinking water, sewerage, and transport facilities. The court further acknowledged that the right to
Adequate housing is a right to access several facets that preserve the capability of a person to enjoy the freedom to live in the city. He also authored various landmark judgments in the arena of criminal jurisprudence, such as judgment in Gulvinder versus State, NCT of Delhi 2018, State versus Bharat Singh in 2014, Naj Foundation versus NCT of Delhi 2009. He was also part of the full bench in Secretary General Supreme Court versus Subhash Chandra Agarwal 2010, where the court ruled in favor of the RTI activist who had sought supply of information concerning declaration of personal assets by the judges of the Supreme Court by holding that such information doesn't warrant the protection guaranteed by Section 18(1)(j) of the Right to Information Act. He authored the judgment in Make My Trip India Private Limited versus Union of India, which dealt with questions involving the powers of tax officials of arrest, investigation and assessment of service tax under the provisions of the Finance Act 1994, where he held that the decision to arrest a person must not be taken on whimsical grounds. It must be based on credible materials. He also held that an officer, whether of the Central Excise Department or any other agency authorized to exercise powers under the Central Excise Act and or the Finance Act, will have to be conscious of the constitutional limitation on the such exercise of the power. During a discussion with Sandra Friedman on her book Comparative Human Rights Law, Justice Muralidhar expressed his views on the need of linkage of international covenants, particularly those ratified by India in the context of Indian cases, and that he endeavored to express these linkages in his judgments. As a judge, Justice Muralidhar had deprecated the use of my lord and your lordship as a form of address to the court. It is indeed very difficult to draw even a broad outline of the introduction of Honorable Dr. Justice Muralidhar within a few minutes of time frame, but it is always an enlightening and inspiring phenomenon to introduce a multifaceted judge like Justice Muralidhar and a renowned jurist like Sri Mahesh Jethmalani. May I now proceed to introduce Sri Mahesh Jethmalani, sir, today's distinguished keynote speaker. Sri Mahesh Jethmalani, Senior Advocate, Supreme Court of India and Honorable Member Parliament. He is the illustrious son of his illustrious father, the great jurist Sri Ram Jethmalani. Sri Mahesh Jethmalani is an illustrious alumnus of St. Xavier's College, Mumbai. He studied law in London under the patronage of the UK Bar. He qualified as a barrister in 1980. Sri Jethmalani enrolled at the bar of Bombay High Court on 12th February 1981. He has been conferred with the distinction as a senior advocate by the Bombay High Court and the Supreme Court of India as well. He has handled several critical criminal and civil cases like the trial of former Chief Minister of Maharashtra, Mr. A.R. Anthule. He also appealed before the court for 2 accused in assassination of Indira Gandhi. He represented Birla family in the Priyambada Birla case and has also appeared for Anil Ambani in the Reliance case before the Supreme Court of India. Mr. Jethmalani represented the then Chief Minister of Gujarat, Sri Narendra Modi, in the Gujarat riot case in Supreme Court of India, as well as the then Gujarat Home Minister, Sri Amit Shah, in this Sohrabuddin case in the Gujarat High Court, as well as in the Supreme Court of India. He also appeared for the bail plea of Sanjay Dutt in the Supreme Court of India. Mr. Jethmalani had also appeared for Harshad Mehta in several cases. He also appeared for former Police Commissioner of Mumbai, Parambir Singh, against the Mahavikas Aghadi government. Sri Jethmalani has leanings towards the ideology of the Bharatiya Janata Party and the Rashtriya Swayamsevak Sangh. He was BJP's national executive member and had contested parliament election being fielded by the BJP. Presently, he is a distinguished honorable member of Upper House of the Parliament, the Rajya Sabha, since 1st June 2021, being the nominee of the President of India, preceded by late Sri Raghunath Mahapatra Odisha. We feel immensely grateful to Sri Jethmalani for he could find some time from his extremely busy schedule to share with us. Sri Ranjit Mahanty, Senior Advocate and Convener of Barrister Ranjit Memorial Committee of the High Court Bar Association, Odisha. Sri Ranjit Mahanty was enrolled in the Odisha High State Bar Council in the year 1976. He joined the celebrated office of Barrister Ranjit Mahanty and continued his practice under him till Barrister Mahanty most untimely passed away in the year 1989. Being trained by his illustrious senior, Mr. Mahanty undertook law practice in almost every branches of law and became an expert in constitutional law. He was conferred with the distinction of senior advocate by the Honorable Odisha High Court in the year 2000. He has been shouldering the responsibility of convener of the Barrister Ranjit Memorial Committee, being the true successor of his distinguished predecessors, late Dr. Bipin Bihari Ratho and Dr. Vibhudendra Mishra. I bow down and I conclude. Thank you.
Respected Chief Guest, Mr. A.S. Muralidhar, and distinguished guest, Mr. Moez Jethamalini, respected senior members of the bar, Honorable Justice S.K. Sahu, and your colleagues and friends. I feel it a privilege to preside over the today's meeting, but I don't want to kill your valuable time, and I will sacrifice my time for our guests. Both of them are very distinguished persons and brilliant speakers. And now I request Mr. Jethamalani to address the gathering. Mr. Jethamalani.
Thank you. Honorable Shri Justice Mulidhar, Chief Justice of the Odisha High Court, Honorable Shri Ranjit Mahanty, Chief Justice of the Tripura High Court, Senior Advocate and Convener of the Barrister Ranjit Mahanty Memorial Committee, Mr. Ranjit Mahanty, Shri Kali Prasanna Mishra, Senior Advocate, Odisha High Court Bar Association, Shri Alok Prasad Nanda, Advocate and Secretary, Odisha Bar Association, Viswajit Mohanty, members of the Odisha Bar, ladies and gentlemen. At the outset, a little personal note and a trip down memory lane. My late father, Shri Ram Jetpalani, was not only a great friend of Shri Ranjit Mahanty, but had a very special place in his heart for him. They shared many common interests, and their relationship was the outcome of a strikingly similar career at the bar. Both were leaders of the bar in their respective home states. My father was the chairperson of the Bar Council of Maharashtra for several years, and Ranjit ji was the leader of the bar in Odisha. Both went on to become chairman of the Bar Council of India. They supported each other's candidature and worked together in the Bar Council to improve the quality and ethics of the bar and strove for the cause of speedy and effective justice. Their early bond was cemented during those dark days of the emergency, as both fearlessly spoke out against the declaration of the emergency, the suppression of civil liberties, and the confinement of lakhs of prisoners of conscience that ensued in that era. My father addressed a huge public rally against the emergency at the instance of the Kerala Bar at Palghar, while Ranjit ji led the Odisha High Court Bar in a public rally to lodge its protest against the imposition of the emergency. A warrant for my father's arrest was issued by the Palghar magistrate under the draconian then Misa law for his fierce speech. When the Supreme Court ultimately upheld the declaration of emergency, my father escaped to America, obtained political asylum in that country, and continued to speak out against the emergency, including testifying before the Congressional Foreign Relations Committee. Ranjit ji continued to fight the emergency both inside and outside the court within this country. I don't know whether Justice Ranjit Mahanty or Biswajit Ji are aware, but one of the few people my father was secretly in touch with from the US when he was in exile was Sri Ranjit Mahanty, and I was personally a witness to a call between them on a visit to America where I met my father when he was in exile. On his return from the US, my father contested the Lok Sabha election from a Bombay constituency against Sri H.R. Gokhale, who was the law minister and had promulgated the emergency proclamation. Many lawyers from around the country came to Mumbai to campaign for my father. Ranjit Mahanty was one of the foremost among them. Thereafter, when normalcy resumed in India, their friendship grew. They were colleagues at the Bar Council of India and met both in connection with the council's work and socially. I personally have had the honor of enjoying the company of Sri Ranjit Ji at dinners, both in Bombay and Delhi, at my father's residence. Suffice it to say that socially too, they shared a common interest in the evenings after a hard day's work. One of the greatest joint legacies of my father and Ranjit Ji was the tireless effort they put in for the establishment of the National Law School in Bangalore with an intensive and today very prestigious 5-year course. Of course, it must be mentioned that this would not have been possible without the efforts of others, notably Professor Madhav Menon, a legal academician of immeasurable stature, and of course, Sri Ramakrishna Hegde, who spared no effort as then Chief Minister to ensure that the land for this university was allocated by the state of Karnataka. The organizers of today's event have very graciously offered me the indulgence of speaking on a subject of my choice, to which I now turn to. During COVID, the Home Ministry appointed a committee known as the Criminal Reforms Committee, of which I was nominated a member. The committee's terms of reference were very wide. Due to COVID, the committee had a time to meet on several occasions, during which extensive discussions were held. Also, because of the limited functioning of the courts during that period, I too had much time on my hands to delve deep into what ails our criminal justice system and wherein lie the remedies. The subject of my address today, broadly speaking, would be making the criminal justice system work. Now, to say that the topic is making the criminal justice system work is not to suggest that the framework of our criminal justice system is flawed or that the system does not work at all. But it is now trite to state that long ago, the system commenced its path down a slippery slope, and that the failure of all stakeholders in the system to check its slide has resulted in the present alarming situation where it is at the bottom of the slope and an avalanche caused by an earth-shattering docket explosion threatens to choke and bury the system beyond redemption. Here are some depressing figures. The all India pendency of criminal trials today stands at about 4.7 crore cases. Of these 87.6% are pending in the subordinate courts and 12.4% in the high courts. Between 2010 to 2020, the pendency across all courts increased by 2.8% annually. Between 2020, pending cases increased by 20% in the high courts and 13% in the subordinate courts. While new cases in 2020 were much less than in the preceding years due to COVID, pendency increased because disposal rate was even slower than the rate of new cases filed. Thus, the increase in arrears grows exponentially every year. In the light of these figures, it is imperative that the tide of arrears is stemmed drastically at the earliest. Now, there's also endemic delay throughout the entire pre-trial process. From the delay in filing an FIR, sometimes willful to protect powerful accused, to complete apathy in filing charge sheets, particularly once bail proceedings are over. Delay and apathy are the hallmark of police investigations. Indeed, it is a conspicuous feature of police investigations that inevitably an incomplete charge sheet is filed within the period of 60 days or 90 days for the sole purpose of denying the accused in default bail. Once that purpose is achieved, the police drag their feet in filing the final charge sheet, camouflaging their apathy by sometimes periodically filing supplementary charge sheets. In this way, the process of investigation persists indefinitely. The malignancy of delay and its concomitant failure of justice, for delayed justice, as we all know, is denied justice, infects even the most heinous of the crimes. Take the example of the history of two of the biggest crimes that shook India, both in the early 1990s. They illustrate the point. The trial in the bomb blast case, which took place, which rocked the city of Mumbai in March 1993, was completed in two stages. The first in 2006, that is 13 years after the incident, and the trial of accused subsequently charge sheeted, which included the notorious gangster Abu Salem, was concluded as late as 2017, 24 years after the episode. In 1992 also, Parliament, in the wake of a stock market scam of humongous proportions, enacted the Special Court Trial of Offences Relating to Transactions in Securities Act. The Act prescribed that all the accused guilty in the stock market scam, in which the late Harshad Mehta featured as the principal accused, would be tried by a judge of the High Court, from whose judgment an appeal would lie only to the Supreme Court. The plethora of cases, both criminal and civil, that were filed before the Special Court necessitated the appointment of first one more judge, then a second, and then a third. At one time, there were 4 High Court judges performing the task of disposing of cases under the Special Courts Act of 1992. Even today, a High Court judge has the assignment of dealing with cases under the 1992 Act, and some appeals from the Special Court are pending in the Supreme Court till today. In other words, ladies and gentlemen, it has taken 27 years to dispose already, and it's not over, to dispose of a category of crimes for which a special court was created, for which the court of original trial jurisdiction was the High Court, and from which the only appeal lay to the Supreme Court. Nor has the new millennium informed the criminal justice system about speedy justice in serious high-profile crimes, serious ones. Afzal Guru was executed for his role in the Parliament bomb blast case of 2001, only in 2013. The trial of Sadhvi Pragya for her role in the Malegaon bomb blast case in Maharashtra of 2008 has commenced only recently, and she was under trial for almost 9 years, having arrested in 2008 and secured bail in 2017. The trial is still going on. On the other hand, a qualified lawyer from Kashmir, one Ghulam Bhatt, has been in custody since 2011 for being a member of a terrorist organization. The trial is still underway. Nor is speedy justice visible in arguably the biggest economic crime in India's history, namely the 2G spectrum case. The crime, which occurred in 2008, was only investigated because of the Auditor General of India's report that the loss to the exchequer on account of the scam was a staggering 1.76 lakh crore rupees, and the monitoring of the PIL by the Supreme Court. First charge sheet was filed in 2011. In the ensuing trial, the special judge acquitted all the accused in December 2017. So much for the Auditor General's report and the Supreme Court's prima facie views. The CBI has now filed an appeal, which is still to be heard. Surely, the biggest economic crime in India's history deserves much speedier disposal, and at least the appeal should be fast-tracked. Did the Auditor General and the Supreme Court commit a Himalayan blunder which decimated the telecom sector, or is trial judge O.P. Saini's verdict a questionable one? The nation needs to know, the nation wants to know. Alas, the biggest stakeholders in speedy justice, the victims of the crimes, can do little to improve the system. Unless the other stakeholders, the executive, the legislature, the judiciary, and the legal profession, take urgent steps to remedy the malaise, crime victims can only helplessly stand by as the tsunami of arrears crushes their hopes of justice. The task of lawyers is constrained by the fact that it is on the government that the major onus lies to stem the rot. Lawyers can only contribute at all times, by at all times being ready to proceed with criminal trials and other proceedings and scrupulously avoiding adjournments. They can also suggest procedural reforms, which, while not eradicating the cancer of arrears in our criminal justice system, can at least mitigate its impact. To some of these reforms, I now turn in the desperate hope that if not bench strength, will, and infrastructure over which only the executive has control, that Parliament at least performs its legislative duty by amending the CRPC to ensure that the laws that it passes conform to the constitutional mandate of fair and speedy investigation and trial. Here are a few suggestions which I have mooted before the Criminal Law Reforms Committee, which is now being considered by the Home Ministry. And I hope that the bill, the Criminal Law Amendment Bill, will be introduced in the next session of Parliament. Here are some of the more salient features. I'm focusing on the ones which improve speed, at least, arrears, and a little bit of quality. First, should investigations be the exclusive preserve of the police? At present, the Criminal Procedure Code envisages a clear demarcation of jurisdiction between prosecutors on the one hand and the police. The role of public prosecutors only commences with the trial. In the sphere of investigation, they have no role to play. Now, this is a little esoteric. Section 25A of the Criminal Procedure Code, which was inserted by an amendment to the code from 2006, prescribes the creation of a directorate of prosecution at the discretion of the state government. This directorate is to consist of a director of prosecution and as many deputy directors of prosecution as the state government thinks fit. Subsection 7 of Section 25 capital A provides that the powers and functions of the DP and the DPPs shall be such as the state government may by notification specify. Now, the rationale behind this enactment of 2006 of Section 25A is opaque. The bare creation of the Directorate of Prosecution, consisting of a DP and as many DPPs as the state government may think fit to appoint, is an exercise in futility unless the DP and the DDPPs are vested with substantial powers by the requisite notification to be issued by the state government under subsection 7. Many state governments have not even issued that notification. If the object of Section 25A is to create a body like the District Attorney's Office in the USA, then Section 25A, even with the discretionary powers conferred upon the state government under subsection 7, is not merely wholly inadequate, but perhaps in patent conflict with the provisions of Chapter 12 of the Criminal Procedure Code dealing with police powers of investigation, under which, as everybody knows, the powers of investigation rest exclusively with the police and the officer in charge of a police station in particular. If, on the other hand, the intent behind 25A was to create an office like the Director of Public Prosecutions in the United Kingdom, the section is redundant, as in India, the role of the prosecutor is already like that of the DP, i.e., one whose function commences only after an investigation is complete. As in the UK, the public prosecutor in India occupies a unique, lofty position, at least in theory, in the criminal justice system. Like the DPP in UK, the public prosecutor must always act with fairness and detachment in conducting a prosecution, with the objectives of establishing the whole truth and ensuring a fair trial. But perhaps, with the benefit of hindsight on the efficacy of our criminal justice system, it is time, and this is one of the suggestions which is mooted, and it is time to everybody support this, I think. It is time for the creation by an amendment to the code of both a directorate of prosecution in the states and one distinct one for the central investigating agencies like the CBI, the ED, and now the SFIO. Must consist of two wings. First, an exclusive prosecutorial agency whose role commences at the same time as the prosecution commences, similar to the role of the existing public prosecutor. Now, the change is the second must consist of an investigating wing whose role is advisory, but must be sought out at crucial stages of the investigation, such as the exercise of the power of arrest, the power to search and seize, the request to the appropriate authority for wiretapping, and the manner of collection of evidence. Of course, the final decision will always rest with the officer in charge of the investigation. But the opinion of the investigating wing of the Directorate of Prosecution, being advisory, may not ensure complete fairness investigation. But coming as it does from skilled lawyers, it will at least serve as a robust check on the rampant abuse one sees in police investigations today. It's imperative now we have a prosecutorial agency which also advises at the stage of investigation. Moreover, it is time that public prosecutors, additional and assistant public prosecutors, are appointed from a pool of the best available lawyers. The fee structure of prosecutors needs to be enhanced, and state-of-the-art technology has to be made available to them. This means access to computers and consequently to search engines, databases, which even the most junior lawyers in private practice are able to access today. A prerequisite for being appointed as a PP or APP should be the ability to utilize the latest technology with skill. This will go a long way in leveling the playing field between prosecutor and defense counsel, facilitating as it does not just the availability of online reports, but also a whole range of academic literature on substantive, procedural, and evidentiary issues, all relevant to the conduct of trials. Moreover, Section 24(7) of the CRPC must be amended to provide that a PP or additional PP can only be appointed if he has been in practice as an advocate for not less than 10 years. Present requirement of 7 years practice is wholly inadequate. Appointment should also take into consideration the number of trials conducted, and particularly the number of trials conducted for a complainant in private complaints. So he has some experience as being a prosecutor before actually being appointed one. Now, trial practice has also revealed that in several cases, an FIR is filed belatedly and also not filed at the time disclosed in the FIR. This is often done to concoct evidence, particularly in the form of eyewitness accounts, in a case where there's otherwise no eyewitness present. Since eyewitness accounts are the fulcrum of many a conviction in serious cases such as murder, accused are often convicted on false evidence. There's a compelling need, therefore, for e-filing of all steps in investigation. This will eliminate antedating and fabrication of records and evidence. Thirdly, now we're coming to time, speedy justice. There is no limit at present to the time the police can take to complete investigations. Once an accused person suffers the humiliation of pre-trial jail, investigation languishes whether he subsequently obtains bail or not. All investigations must be time-bound. Section 173, 1 capital A, inserted by an amendment of 2008, has already made a start in this direction by prescribing that the investigation in relation to the rape of a child must be completed within 3 months from the date on which the information was recorded by the officer in charge of the police station. We have suggested in the Criminal Law Reform Committee that all offences punishable up to 3 years investigation must be completed within 3 months from the date of the registration of FIR. Those up to 7 years within 6 months, and offences punishable with 7 years and above within the period of 1 year. In cases involving terrorism and cross-border money laundering, the maximum period permitted for completion of investigations can extend to 18 months. These timelines will not cause any prejudice to the investigating agency, as if they obtain further evidence under Section 173(8), all criminal practitioners know, they can always, with the permission of the court, bring that evidence on record at any time before the conclusion of trial, subject, of course, of the right of the accused to cross-examine the new witnesses or the new evidence that is produced. Next, the above investigation timelines should be rigorously enforced by a magistrate, referred to in Section 156(3) of the CRPC. A view expressed by a bench of the Supreme Court in Sakiri Vasu's case, many people would have read that such a magistrate can monitor investigation under this section has rightly been doubted in a subsequent decision, since earlier decisions have held that a magistrate ordering an investigation under 156(3) becomes functus officio once he passes his order. Section 156(3) should be suitably amended without detracting from that view. If a magistrate referred to in one section 56(3) is vested with limited power to ensure that the time limit for investigations are duly complied with by the police, he can have, post his 156(3) order, he can ensure that at least the time limits which are going to be incorporated for investigation are adhered to strictly by the police. Then 167 should be amended to provide that the magistrate judge is obliged to inform the accused of his right to in default bail, and that bail must be granted even on the oral request by an accused. If the accused does not want to avail of bail or cannot do so, an assertion in writing signed by the accused must be obtained from the magistrate and become part of the remand proceedings. Too often, we are told by courts that the accused or the public prosecutors that the accused never informed us that he wants to avail of his in default bail. If that's the case, 90 days or 60 days, you must ask the accused, you have a right now, you want to avail of it. And if he doesn't, record it in writing. Then, of course, Section 1, a new Section 167A should be added to provide that an indigent accused should have access to legal aid right from the time of his first remand, not only during trials. His liberty is as precious as anybody else's. Seventhly, Section 311A, as it presently stands, empowers a magistrate to pass an order directing any person, including an accused person, to give a specimen signature or handwriting. And the person to whom the order relates shall be produced or shall attend at the time and place specified in such order and shall give his specimen signature or handwriting. To facilitate the discovery of relevant facts in an investigation or other proceeding under the code, a magistrate should similarly be empowered to pass an order directing any person, including an accused person, to provide his password, face scan, touch ID, so that his mobile number and other electronic devices can be opened by the police. This is, a lot of people are going to say that this is compulsion, but the crimes that are taking place in this country require that these kind of aspects of privacy should be waived. All trials must be, now we come to trials. All trials must be time bound from the day the charge sheet is filed. Addressing a conference on the national initiative to reduce pendency and delay in the judicial system, organized by the Supreme Court of India in collaboration with the Indian Law Institute in July 2018, the late Professor Madhav Menon concluded with an appeal to the judiciary to give priority to criminal cases in the initiative proposed, and that no criminal case should linger on in the justice system for more than 3 years. And a clear message in this regard should go to the police and the prosecution. Parliament should now honor this man who has done so much for the criminal justice system in the country, to honor him by providing that all trials in cases should be completed within a period of 3 years from the time when the accused first enters his appearance before a magistrate or presiding judge of a court. This timeline can be prescribed by inserting a new section 309A. That's our recommendation again. Then, the mandate of 309 of the CRPC, that in every inquiry or trial proceedings, the trial shall continue from day to day until all witnesses have been examined, should be strictly adhered to. So also, the fourth proviso to section 309, setting out conditions as to when an adjournment will be granted to a party, that must be strictly adhered to. And finally, when adjournments are granted, they must be made only on payment of costs by a party, commensurate to its financial status. Parties must pay the highest cost proportionate to their means for protracting trials. Then, of course, 320, dealing with compounding of cases, should be amended to mandate that magistrates trying compoundable offences must refer those cases to mediation, and with the assistance of mediators, endeavour to enter into settlements that are enforceable. That, to some extent, is already taking place. Section 251 of the CRPC should be amended so that an accused is able to apply for a discharge in a summons case. In the absence of this provision, either the trial courts are burdened with protracted trials in petty offences, or the High Court is flooded with Section 482 petitions seeking to quash process in summons cases. Timelines should be fixed for filing and disposal of discharge applications. No discharge application should be entertained after 6 months of the accused being furnished with a copy of the charge sheet or being served with a copy of the complaint. Replies by the state should be filed within 2 weeks of the discharge application being filed and served upon them. The trial court should thereafter dispose of discharge applications within a month thereafter. All these timelines can be brought about by an appropriate amendment to the discharge provisions in Chapter 18, Chapter 19A, and Chapter 20B. We have already recommended all these. I hope when the final draft bill comes out, most of these are incorporated. Now, conviction rates in criminal cases, particularly serious ones, are abysmally low. All India trial court conviction rates are about 40%. This figure is reduced to almost half on account of conviction appeals being allowed by appellate courts. An endemic reason for low conviction rates is witnesses turning hostile. Now, ever since the beginning of my practice, I've been wondering why Section 162? What is the rationale? 162 is where you can't sign witness statements. This has to go. Witnesses can resile from the police statements because Section 162 of the CRPC prohibits the signing of witnesses by the person making it. Witnesses are not bound by their police statements since they have not signed it. Section 162 should be amended to remove this prohibition and to mandate that witness statements should be signed. I mean, these provisions are there in America and the UK. Such a provision will also ensure that the police cannot fabricate witness statements. It helps both sides. Witnesses can turn hostile, either if they are won over or if the police have put words into the statements which they never uttered. By making it mandatory that police statements be signed by witnesses, both these present rampant abuses can be checked. I mean, there are sometimes some very simple solutions for what is becoming a curse in our system. That the only way to deter perjured testimony and professional witnesses is by courts taking frequent recourse to perjury provisions. Once prosecutions for perjury are initiated by courts, witnesses will refrain from giving false testimony on oath. So that perjury prosecutions can be strictly disposed of, the CRPC should be amended to the effect that all cases of perjury, and not just cases referred to in section 344, they should all be tried summarily and disposed of quickly. Now, the nature of economic crimes in more recent times has become more complex, has cross-border implications, and the quantum involved has reached mind-boggling figures involving thousands of crores of rupees. The time has perhaps come when original jurisdiction in criminal cases can also be classified on pecuniary grounds. Here's a suggestion. Trial of crimes involving financial loss or gain up to 100 crores may be tried before a magistrate. Up to 1,000 crores by a sessions court or a special judge who's a sessions court judge. In a case involving any amount above 1,000 crores, the High Court, which has an extraordinary criminal jurisdiction, it should be vested where it doesn't with an original trial jurisdiction by the insertion of a new section prescribing such original trial jurisdiction based on the pecuniary grounds. And otherwise, the system is not working. Now, here is a suggestion for High Court judges. The superior courts, particularly the High Courts, can exercise its inherent powers liberally to relieve the trial courts of the crushing burden of pending cases. Several police investigations consist of private disputes, corporate or individual. Most of these cases are essentially civil in nature, but because of the even greater pendency of cases on the civil side, private parties seek recovery of property or enforcement of commercial contracts through the agency of the police. Every criminal practitioner knows this. In more than one case, the Apex Court has lamented the growing tendency of litigants to invoke police powers of investigation and particularly the power of arrest to enforce what are essentially civil claims. The court has cautioned that criminal proceedings are not a shortcut when other remedies are available, and that the police cannot be a recovery agency for private parties. Unfortunately, many high courts are loath to entertain petitions for quashing in matters which are criminal only because of some clever drafting in language, reciting ingredients of criminal offenses distorted to apply to facts which disclose only a civil dispute. The reluctance of high courts to weed out these abuse of police powers is often based on the principle that the power of quashing under 482 should be exercised rarely and with utmost circumspection. This has become a cliche now. The invocation of this principle for non-interference with mala fide police investigations continues to encourage litigations to seek police help for financial recoveries under the guise of criminal offenses. Any high court judge can easily separate the grain from the chaff and quash what are essentially civil disputes. If the High Court only exercises its powers more liberally under 482, given the growing tendency of litigants to liberally approach the police for civil claims, it will be discharging its duty of superintendence of courts subordinate to them, and thereby, far from relieving, if they don't do this, far from relieving trial courts from the burden of arrears, they will only aggravate them. So 482 should be liberally invoked, and in many cases it's not being invoked. The vast majority of cases, the courts are reluctant to go into them, and on some pleading by the police, they don't interfere. They don't cause criminal investigations. Which brings me finally to the root cause of pervasive delay in all the courts of the country. As per data published in court news and annual reports of the Supreme Court, the sanction strength of the subordinate judiciary as of February 2020 in the country is 24,018, but almost 21%, i.e. 5,146 per line vacant. Some of the high courts, as we all know, are functioning with less than 50% of their sanction strength. The law minister himself recently admitted that lack of judges is the foremost reason for high pendency in subordinate courts. India has one of the worst judges to population ratio. At present, we have only 19 judges per million of our population. The need of the hour surely is for the judiciary and for the government to work in tandem and address the issue of improving the functioning capacity of our courts in order to lessen the burden of pending cases. Parliament can legislate all at once, but unless the judiciary and the executive put their heads together, this deficiency is not going to be cured. Finally, ladies and gentlemen, the famous French judge, philosopher, and principal source of the famous theory of separation of powers, Montesquieu, he once cautioned, there is no greater tyranny than that which is perpetrated under the shield of law and in the name of justice. It is well that all authorities concerned with the dispensation of criminal justice in our country heed his words before our population, despairing of seeking justice through our judicial system, takes the law into its own hands. I thank you for the honor of addressing this very august gathering.
We are extremely thankful to you, sir. You accepted our request and delivered the law lecture. And once again, I extend my thank to you, sir. Once again, I welcome our Chief Justice, Dr. S. Muralidhar, and I request him to address us, sir.
Good evening to everyone. I am honored to be invited to address the August gathering to commemorate the 33rd commemorative day of Barrister Ranjit Mahanty. I can see in the audience my colleagues, Justice Sangam Sahu, Justice Savitri Ratho. I am delighted that Justice Indrajit Mahanty, Chief Justice of Tripura High Court, has joined us virtually. It was a pleasure listening to Shri Mahesh Jethmalani, Senior Advocate, and equally a pleasure to listen to Mr. Sanjit Mahanty, Senior Advocate and convener of the Barrister Ranjit Mahanty Memorial Committee. Shri Shubha Prakash Panda was, I think, over generous in his introduction of me, but I'm very happy to have come to the Orissa High Court as a Chief Justice because of the experience I've had in the last 18 months, which has been enriching, enlightening, and every day has been a learning experience for me. Personally, I must record deep satisfaction at being a judiciary in Orissa, which would not be possible without the cooperation of the bar in the High Court, the bar in the district courts, my colleagues in the High Court, the judicial officers in all the district courts in Odisha. I said this on the previous occasion when we had the 32nd commemorative day of Barrister Ranjit Mahanty, that I would consider it one of my misfortunes that I did not get to know this great personality during my professional life. And I know I would have benefited immensely had he been around when I came to join this court. I've heard so much about, reaffirmed that personality of Shri Ranjit Mahanty, of being a true leader of the bar, of being a statesman, of being a person who cared for people and was looking beyond his immediate need and concerns and thought for the nation as a whole. Orissa is very fortunate to have had such stalwarts as Shri Ranjit Mahanty, leading them from the front. I would not like to respond to Shri Mahesh Jethmalani's erudite lecture, much as I'm tempted to. It takes me back to my lawyering days, and I know I must resist that temptation. But I would only like to add this, that I will wait to hear Shri Mahesh Jethmalani speak to us on another occasion on the role of the lawyers in all of that he has suggested. Having come over to this side and having now a 360-degree view of how our criminal justice system works, I'm sure he will agree with me that the role of the lawyer in the criminal justice system is almost central to the whole system. And without the cooperation of the lawyer, much of what Mr. Mahesh Jethmalani prescribes may not succeed to the extent that he desires it should. I would only urge this and this to Mr. Mahesh Jethmalani as a parliamentarian, since he represents the people in the Rajya Sabha, that the consultative process must be widespread. We've had a tendency to consult certain groups of citizens when we have prescriptive measures. I would urge that this consultative exercise must, of course, include the bar councils and the bar associations, but also a range of other players, including people who've engaged with the criminal justice system as victims, as witnesses, as persons suspected of crimes, of persons who've served sentences in the criminal justice system and have emerged. Because all those stories will tell us what the criminal justice system is about, how it works, what are its weak links, and how do we need to address those weak links. From the point of the judiciary, I would like to share with Mr. Jethmalani one concern that we've been voicing, namely judicial impact assessment. Every time we have a new law that is introduced, a new action that is criminalized, like just take an example of Section 138 of the NI Act, that one provision in the law has enormously increased the burden of the judiciary in lakhs of cases across India. So we need to understand before we prescribe a new legislative measure, what is the impact of that legislative measure on the judiciary? What will it do to the pending cases and ideas that we talk about? Are judges equipped to deal with that new pressure? Are lawyers equipped to deal with that pressure? Is the litigant public equipped to deal with it? Is the investigating agency, the law enforcement agency, as a ready fix to a social problem that we've faced without really, and on the legal system as a whole? There is a very Ganadharao, of which Mr. Madhav Menon, a member, they came out with this report assessment. I think it needs to be taken off the shelf, dusted off and read, and not allowed to languish there like many reports do. So that will give us an idea of the multifaceted problems that the legal system faces from a variety of actors. And now as a Chief Justice in Orissa, I've become deeply conscious of the role of lawyers in taking trials forward. Orissa has 85% of the cases in Orissa subordinate courts is all criminal cases. And when we try and accelerate the pace of trials, we do face issues on participation of lawyers in criminal trials. The participation rate of lawyers at the stage of bail is much higher than it is at the stage of trial. And that is something we all need to collectively interrogate, whether as the judiciary, whether as the bar councils, whether as bar associations. What is the impact the abstention from work by lawyers across the country? I'm not just talking of one or two places in Orissa or one or two places in the country. Across the country, we have instances of bar associations passing resolutions urging lawyers to abstain from work for a variety of reasons. What is the effect of that abstention from work by lawyers have on the progress of criminal cases? This is something a person like Mr. Mahesh Ditulani, who's a very senior lawyer and who's had a great fortune of watching firsthand how his erudite father worked with the lawyers, with the bar councils, with the bar associations. He would have a very rich contribution to make on this issue of what is the contribution, what is the role of lawyers in advancing the goals of the criminal justice system. I do not want to dwell much more on this because it has been a very erudite lecture by Mr. Jethulani. He has given us much to think about. And I'm sure people listening to his lecture today, and if some of them are in a position to bring about some of these changes, will take some of his suggestions and carry them forward. I just want to dwell on a certain aspect because it is a Ranjit Mahanty commemorative day on the role of the senior lawyers in our legal profession. When we look at the exemplars that we would like to emulate as legal luminaries, as senior advocates, the names that readily come to mind are Shri Ranjit Mahanty, the barrister and senior advocate, and of course, great personalities like Shri Ram Jethulani, Shri Nani Palkhiwala, and even among contemporaries, Shri Nariman, Shri Surabji, Shri Venugopal. So we can multiply the names, but I think there are certain facets of their functioning as lawyers, which we really admire. Among these facets, and this is just to remind ourselves that this is the standard, this is the bar we should set for the functioning of a senior lawyer. One is thorough preparation. I have watched Shri Ram Jethulani prepare in criminal cases. It is simply unimaginable the extent to which, the detail to which he would carefully prepare his notes, written by hand in a register maintained by him, and would very meticulously go through the papers if he's preparing for a final hearing. And you can see that he sticks to the script that he's drawn out, the scheme that he's drawn out for his arguments. It was something as a young lawyer, I had the privilege of watching from across the aisle. And I would never forget those days when we watched Shri Jethulani in action in the court, those pregnant pauses between statements and the impact it had on the court through sheer brilliant advocacy. We've had the fortune of watching many of these great lawyers in action. And one thing about them is the thoroughness of preparation. That is how they earn the trust of the court, because the court can believe that when they say something which is relating to a fact in the case, they can be trusted to say the right, place the correct fact and not mislead the court. The second trait that one watches in great senior lawyers is true independence, combined with professional competence. When we say independence, it means ability to think objectively about the law, which is why if there is a decision which is against you, a senior lawyer will very frankly tell the court, this is a decision against me. But he might try to distinguish it if he can persuade the court to do that. But no senior lawyer who's worth that gown that is bestowed on that senior lawyer will keep back from the court a decision which is against him and only place a decision which is in favor of his client's case. The third is the ability to think on one's feet. There are very knotty problems that can come up in court. If you've watched these great senior lawyers in action, you will find how they're able to tackle these very knotty problems in court. It could be a difficult case, it could be a difficult client, it could be a difficult opponent, It could be a difficult judge. It could just be a difficult day. But these senior lawyers know how to carry that day, how to forward that case, and how to steer it through this maze and through these difficult, turbulent waters. That is the greatness of these senior lawyers. And without losing their calm and cool, they've been able to overcome these difficulties. My own senior would tell me that the true mettle of a senior advocate is not how well the senior advocate does in an easy case, but how well the senior lawyer does in a difficult case. That is the true mettle of a good senior lawyer. The fearlessness that one looks for in lawyers is something to be admired. I've seen Shri Ram Jethmalani deal with these situations. I've seen many more erudite senior advocates deal with these situations, where they've demonstrated that they're not overawed by the bench, but at the same time, they knew how to maintain the decorum of the court. They never raised their voices, they never lost their temper, and maintained the dignity of the proceedings. So the ability of the senior lawyer is to demonstrate fearlessness, but at the same time maintain decorum and dignity of the court. If you start abusing the court because the court does not agree with you, then there is something very essential to those proceedings which is lost. Then it completely mars the proceedings. Good senior lawyers, for that matter, good lawyers, know how to navigate these difficult moments and maintain the dignity and decorum of the proceedings. When we talk of great senior lawyers, these are the qualities that one looks for. And I'm sure in days to come, there are many young lawyers today watching many senior lawyers in practice. They will pick up the best traits of all these senior lawyers, recall what were the good traits of the earlier senior lawyers, have a benchmark of these best practices and try to emulate them. The Indian bar today has many promising young lawyers. I am not a person who is prepared to be cynical. I know there are many bright young lawyers who are going away from litigation into corporate law practice, but there is still a sizable number of them, young bright lawyers, whether women or men, coming into the legal practice and contributing richly to the development of the law and to the proceedings in the court. I'm sure they will emulate some of these best practices laid down by stalwarts like Shri Ranjit Mahanty or Shri Ram Jethmalani and carry the flag of the Indian legal system, the Indian bar, and the Indian judiciary flying high. I just want to add one aspect to what Shri Jethmalani said about the vacancies in court. Shri Jethmalani may want to reflect on this because he's in a position to do so even as a member of parliament and to give the right kind of input to those who may want to see positive changes. When we look to recruit judges for our judicial system, he was well aware that if 5,000 applicants come forward, we're not able to choose 50 among those 5,000 applicants. At the intermediate level of the district judiciary, when we advertise for filling up posts of additional district judges from among the bar, and I'm talking of lawyers with 10 to 15 years of experience. In Odisha, we drew a blank last year, and this year we will be able to recruit only one among all those lawyers. So this tells us something about the quality of the bar. This is something that should give us cause for concern. We cannot simply fill up vacancies in the judiciary with any and every lawyer. We need lawyers who have a certain degree of competence, an ability, an aptitude, and definitely a willingness to excel in what they do. And only then the judiciary can be strengthened and we can hope for a truly independent judiciary that is able to meet all the challenges that Shri Jethmalani spoke about. So this is what I keep telling the lawyers in the district courts whenever I go there to address them, that the district bar must have on-the-job learning for young lawyers so that they can participate in these exams for judiciary in greater number and join the judiciary in greater number by improving the standards of the bar, by improving their own skills, so that we combine, we cooperate, we collaborate to strengthen the hands of the judiciary. We need bright lawyers to become judges to strengthen our hands. And that, I'm sure, is a task laid out for us for the future. It has been a pleasure listening to Mr. Jethmalani. It brought back rich memories of his erudite father, a brilliant lawyer. And I watched Mr. Jethmalani himself in action, and I can say he's really a true exemplar of the Jethmalani School of Law. Thank you for inviting me for this wonderful occasion, when we celebrate the memory of a genius of the Odisha Bar, Shri Ranjit Mahanty, Barrister Ranjit Mahanty. Thank you. Jai Hind.
Now I request Honorable Justice Sangam Kumar Sahu to kindly present the books to the lawyers from different bars, because every year we distribute the books to different deserving young lawyers from different bars. Today also we are doing the same. I request Honorable Sri
Chaudhary Vigyan Sis Mahapatra from High Court Bar Association. Miss Pinni Mishra from Odisha High Court Bar Association. Miss Pinni Mishra. Sri Vishnu Prasad Mishra from High Court Bar Association. Sri Vishnu Prasad Mishra from High Court Bar Association. Sri Amarendra Prasad Sahu from High Court Bar Association. Sri Amarendra Prasad Sahu. Now from Kotak Bar Association, Miss Priyanka Jana. Kotak Bar Association, Miss Priyanka Jana. From Criminal Courts Bar Association, Kotak, Sri Sandeep Raj Ponda. From High Court Bar Association, Miss Anupama Mishra. Miss Anupama Mishra. From Board of Revenue Bar Association, Sri Unmesh Panigrahi. Revenue Bar Association, Sri Unmesh Panigrahi. And Sri Sanjeev Kumar Sethi. Sri Sanjeev Kumar Sethi. From Board of Revenue Bar Association, Sri Sanjeev Kumar Sethi. Consumer Bar Association, Sri Udainath Sahu. Consumer Bar Association, Sri Udainath Sahu. Mr. Gautami Buddhapriya. Gautami Buddhapriya. Debts Recovery Tribunal, Rajesh Ranjan Sahu. Sri Rajesh Ranjan Sahu. And Sri Sheikh Aziz. The Barrister Ranjit Mahanty Memorial Committee has selected to give books to the Vasudevpur Bar Association Library. So I request President and Secretary of the Basudepur Bar Association kindly receive the books from my Lord Honorable Justice Sangam Kumar Sahu. Thank you.
Now may I request our Assistant Secretary to propose vote of thanks.
Namaskar. Honorable Dr. Justice S. Muralidhar, the Chief Guest, Honorable Member of Parliament and Senior Advocate Mr. Mahesh Jetmalani, the keynote speaker, Sri Kirot Kumar Rao, Vice President, and Sri Udit Kumar Jena, Joint Secretary of High Court Bar Association, Honorable Judges of Odisha High Court Bar Association, Odisha High Court, esteemed senior members of the bar, and my dear friends. I, Rashmi Ranjan Mishra, Assistant Secretary of Odisha High Court Bar Association, stand before you to propose the conventional vote of thanks. At the foremost, I, on behalf of Barrister Ranjit Memorial Committee of High Court Bar Association, extend heartfelt gratitude to the Honorable Chief Justice, Honorable Dr. Justice S. Muralidhar, for his gracious participation in the function and for his kind words upon repeating the occasion. We are equally honored to Honorable Member of Parliament, eminent jurist, Mr. Mahesh Jetmalani, for his participation in the program as the keynote speaker, who delivered an illuminated lecture as a part of the Barrister Ranjit Mahanty Memorial Law Lecture Series. We are further grateful to Honorable Judges of Odisha High Court for their kind participation in the program through High Court Note. We are immensely grateful to respect family members of late Barrister Ranjit Mahanty, including Honorable Justice Indrajit Mahanty, Chief Justice of Tripura High Court, learned senior and others members of the bar, the esteemed convener and the member of the Barrister Ranjit Memorial Committee, the esteemed office bearer and staff of High Court Bar Association, particularly to Mr. Kirot Kumar Rao, Vice President, and Mr. Udit Kumar Jena, Joint Secretary, the law student members from the academic, esteemed members of the Register of Odisha High Court, particularly Mr. Registrar General, Mr. S.P. Rai Chaudhary, Coordinator, Central Processing Unit of Odisha High Court, friends from the media, members, sanitary staff, security personnel, last but not the least, to Mr. Sanjay Mahapatra, advocate for the unique contribution to make the function a grand success. Thank you all.